Now it's gone, it's 1 hour. She's still not here. I'm not that type to keep quiet when nonsense happens. Nonsense is nonsense. I don't care who's doing it, whether a judge or a magistrate. It's absolutely rubbish. It's unacceptable. We've been too quiet for 5 years. We've been subjected to this nonsense of disrespect. Can't be disrespected like that.
She said she wants some changes. She said that she's calling us some changes.
Calling you to join.
She's saying that they said want to see all of us in changes. She said.
I'm not prepared to talk in chambers. I'm going to talk in front of my client. We can talk in front of my client. You can go. I'm not coming.
No, I agree with you.
Did you get the charge sheet, Advocate Caesar? I handed it to Ms. Magin. Sorry? Are you sure? Alright, we'll continue in the meantime now with 11 speech. Sorry, he's just fetching. No. Oh, he's gonna come through. Apologies, he's just fetching the charge sheet. Quite sure that in the interim we can go on record without, and the charge sheet, it will be shortly because there are a few issues to be discussed. Wait, is the clock not here?
She went to go fetch the charge sheet.
Okay. Oh, we are on record?
Yes, thank you, Worship. The date is the 13th of September 2023. The parties are the same as yesterday. Presiding officer Mrs. T. Quality, public prosecutor Mr. J. Caesar, defense the holders for accused number 1, the nephews for accused number 2, interpreter Ms. Murray, clerks Ms. Matrina. Bishop, this matter is partly heard. There was no concerns yesterday until today. The state is ready to proceed. Just to place on record as well, that we have subpoenaed Mr. Mwatleka and that he is present today.
Thank you. While I wait for the charge sheet, the defense for accused 1 ready, Advocate Hodes, as well to proceed.
Yes, Your Worship.
Advocate Matthews, thank you. The second part, which I'll also record on record, but at least we are recording, is I'm not late. I had extended an invitation for a discussion in chambers from the state and the defense. I waited in vain, and I was told 10 minutes ago that such request was declined by the defense. That is why I'm only entering now. Am I correct in my information received?
Partially.
Yes.
Worship, we were only informed that you wanted to see us in chambers a few minutes ago. Long
No.
after the time.
It was at about 11:15.
I'm saying we were under
Yes, so that, but you declined that offer.
Your Worship, I want to place on record the following. I think it's important because I don't want you to think that you are just...
No, not at all.
System.
I just want to be
I
sure.
would prefer that any discussions which take place in open court.
That was my idea too, but so that we come to court and place on record, it wasn't going to be a closed in chamber discussion, but that we enter court on the same page and then place all on record. That was the point of it, but I understand. Advocate Otis?
Bishop, I confirm we were also only told of the meeting a few minutes ago, well after 12 o'clock, not at 11:15, and that the consensus was that it's better to have everything in open court.
And as I say, by all means, I think we've reached the stage where everything that we say should be on record.
As we should.
All right, so the aspects I wanted to discuss before the court, I've taken note that the witness is present, as the state has informed me. And then I'll start with you, Advocate Odes, because the discussion will decide or be decisive in my decision as to what I intend to do. Monday, you had stated very clearly that the court warned the witness for the 30th of January, and that Advocate Collins has made copious notes which were typed stating I warned the witness. Can you please inform me on which date I warned the witness?
Bishop, you said Hodas, but I wasn't on the...
No, sorry, Matthews. Excuse me, Advocate Otis. You're not in the line of fire, neither is Advocate Matthews. I just want to know the date, please.
I don't mind being in the line of fire. I've been there many times before.
Oh,
I'm reading from the notes of my learned colleague.
Certainly.
It was weird.
look, I'm not disagreeing. I'm wanting to gather the information.
On the 4th of March,
Yes.
the worship informed us, as you indicated, that the court's questions for that witness would be held over to avoid a recall in terms of section 186.
Correct.
Of course, that's the wrong section, it should be 170 something. On the 30th of January, the witness was in fact present
Yes.
in the dock.
Correct.
All right.
Yes. My
The
question
worship
is
with respect, seemed to be somewhat confused as to why he was here.
correct. My
And
question.
we then explained to you that you had said you were going to hold over the questioning of this witness.
Correct.
Whether you had warned him to be back on the 30th of January,
Yes.
I don't recall myself, but something must have happened to have him here. He
No,
wasn't just gonna pop
exactly.
out of the woodwork.
But Advocate Matthews, please, the record, if we can listen to it, you informed the court warned the witness for the 30th of January. And I disagreed with you on that aspect. So I don't know if you want to withdraw that statement or tell me on which date I warned the witness to be present on the 30th of January.
Well, I'd like to listen to the record. Could we adjourn while I listen?
May I also just then, for that purpose, give you my input, and that was the purpose of it, so that we can all place everything on record. That was the purpose of the meeting. The only transcription that this court has is that of the week, not the week even, is only of the witness that stood over, because it was of a technical nature. And we dealt with various witnesses on the 3rd of March. We started on the 1st of March. Various witnesses, 1, 2, 3, 4, 5. Postponed to the 2nd of March. On the 2nd of March, we listened to 3 state witnesses. Postponed to the 3rd of March, on which date we started with the ballistic expert. Rolled over to the 4th of March. Evidence in chief finalized, Advocate Odes finalized, Advocate Matthews finalized, re-examination by Advocate Caesar finalized. Then I will read out to you what was said. That is the only part that I have a transcription of, is his evidence. Okay. And then I will also give a suggestion. All right. It reads as follows. The state saying no further re-exam. Then the court at this point to the defense and the state, since I received the bundle yesterday afternoon, my way of working is I actually read every word in every sentence on every page of every document. So at this point, I cannot say that there is no questions by court. But not to delay the matter, I would at this point say we will excuse the witness, and then with the understanding that should the court seek clarity, it may call the witness on aspects in the report, or I can adjourn now, read the documents and come back. It was then, I can read Advocate Hode's, but it comes down to, yes, there's no objection to that. We cannot stop the court to call a witness. And I stated, I am stating this because of transparency, so that everyone is on the same page and you are not caught off guard. So then, Advocate Hodes requested that we start marking the exhibits that was listed, but at first then the court said to the witness, thank you very much. At this point now we have finalized your evidence. You are excused for now and you may stand down. Then we started marking the exhibits, and the matter was postponed thereafter to the 5th to the 9th of September, on which dates the court was supplied with letters from the defense requesting a postponement in absentia of all parties to the 30th of January to the 3rd of February, which was done. So I do not know at which stage this court warned the witness.
The question is, how did he know to come back on the 30th of
I think that is what I want to ask the state.
Because
if
he
they
was back here on the 30th of January.
Yes, and it caught me completely off guard because I stated clearly on record that I will notify all parties in advance when and such time comes so that you are prepared.
I understand you and I accept what you said.
Yes.
But on the 30th of January,
He was here.
he was here.
Yes.
You were then informed that this is the witness that you
Yes,
sit down because
and
the court might have questions. You then informed him that the court has no questions.
That is now my next suggestion. At this stage, then I'll hear from the state how the witness ended up being present on the 30th of January because it was not at my request. And secondly, we then play the recording of the 30th of January for us all to hear, because that will determine in terms of what section or what procedure the court must follow. Questions by court, or if I am then going to record or not. I think that will eliminate any uncertainties or Advocate Caesar, just so that we all know, was the witness subpoenaed for the 30th of January?
I'm not 100% sure. January is like 9 months ago. I cannot recall exactly what the position is. In all probabilities, the witness must have been subpoenaed by the state.
The court requests such a subpoena.
No.
It was just anticipating that perhaps the court will be ready.
Yes, that's correct.
And I walked in not knowing he's here.
That's correct.
Okay. Advocate Otis, anything you wish to add?
Bishop, I think the only way we're going to get to the truth of this, because we've got notes but they're not accurate, is to listen to the record of the 30th of January and the witness was here and what transpired then.
Yes,
I
so
have the record, let me place it on record, Your Worship, that the witness was here, Your Worship was astounded or taken aback to
Yes.
see him, but Your Worship then excused him.
Yes.
Because you had no questions for him. So I think it's important. I'm not
I
certain
don't
of
think
that.
I'm saying, yeah, all right, let
That's
me.
all, let's listen, I'm not going to...
And then based on that, I can either concede indeed that was so and know what steps or the correct way forward, and if not, decide on the way forward.
Yes, Worship, yes.
That is what I intended, and that was part of the discussion so that we can get the recording ready and everything and place it all on record. That was the only reason why I requested to see parties. Obviously now I will need to give our clerk the opportunity. It won't take long to retrieve that part of the date, and since it was right in the beginning of the proceedings, it shouldn't take long, and once she's ready you can inform me and we can all listen in open court to the recording.
Yes, Your Worship, I have a request that I also wish to make. Insofar as Your Worship has a transcript of this witness's testimony, may we borrow two copies, Your Worship, because we were trying to, we were told yesterday that he's not coming because the witness had said, we were told by Mr. Caesar that the witness had said he was no wise being called back. So we left it at that, we never prepared on him. So
that is what I prevented. Exactly what you are saying now, Advocate Dowd, is that I would tell you in advance that when the court is... Now, unfortunately, my transcript is full of marks and notes, and maybe we can get a printed copy somewhere. If I can't recall if it was emailed, but due to the fast speed that we did the case and the terminology not normal court lingo, I had to study it and then see if I could understand from the record. That was the purpose of just obtaining that part of it.
I appreciate it, Bishop. But if Your Worship is going to ask him questions that premised on the transcript and also to enable us to prepare, I would request a copy because, as I said, Mr. Caesar told us yesterday he's not coming back. We then prepared for the investigating officer for today because we're told that's the last word.
Well, we can do it in that order too, but I don't know why Advocate Caesar would say something like that.
I have a witness, but I don't want to go into this.
No, this is what I did not want to happen.
Just saying what you were told. You can deny as much as you want, so there might even be a recording of it because it was in court.
I'm not
That's not
really...
the issue, Your Worship. The bottom line, Your Worship, is we prepared for the cross-examination of Colonel Swartboy. We even anticipated because he's got 23 odd statements.
It will take all day and tomorrow.
Allocated time today and can continue to tomorrow.
Yes.
But that's just by the issue, and I don't want to get into a personal fight. But I'm not standing down against what I said. I stand by what I said. I heard it.
No. Look, what happens when I'm not present, I really don't want to be a part of.
That's why it's better that everything's on record.
Yes.
So the point that that my request is, should we proceed with this witness, we request a copy of the transcript that ought to be available at the press of a button.
I hope so. I hope so. So that is exactly, and I'm emphasizing the point why I stated each time I will notify all parties so that you may be ready for that day. And then it still backfired for some unknown reason. As I say, unfortunately, look, it's marked everywhere and with my little questions. My questions are basically, and I can say in an open court, of a technical nature. The names, terminology, definitions. I'm not touching on chain evidence, etc., but if we proceed with Colonel Swartboy today, as you prepared for him, it's fine. In the meantime, while we wait for to listen to the transcribed record, I will quickly run through the emails and see if they emailed me a copy, and then I can email it to everyone.
Thank you.
Okay, so for now, then let us see what we can retrieve and hear, and then please call me when you are ready. Otherwise, whoever comes, make sure a second one calls me, because then it seems as if I'm not coming. I'll just leave everything here. This is all I need. Go to the chair. Thank you. So So that you now know just the beginning of the 30 January 23, the start of the proceedings. Thank you.